rights. Thank you, Mr. Speaker.
I call David Clendon.
Thank you, Mr. Speaker, and I am pleased to take a short call on this bill, this third reading of the Evidence Amendment Bill. It's a special pleasure because it's not that often we can actually wholeheartedly support a government justice bill. All too often their amendments or their new bills are locked in an unfortunate and very dated sort of punitive 18th or 19th century model. Gladly, this bill is not one of those, and we've been pleased to support it throughout its journey through this House. The bill does some useful and positive things. I guess our only objection or our only criticism of this bill on the way through, particularly the committee stage, was that it could have actually done more. There were a few provisions we would have liked to see included in it, and we had SOPs to that effect, but so be it. The bill as it is does some useful, positive things, and we are happy to support it. Just not to restate what's already been said, but of course the bill does, among other things, protect video records where any sort of digital recording is made of witnesses or of evidence, whatever it might be. There are some fairly rigorous boundaries, some safeguards put around the integrity of that information, and that's critically important, of course, in this digital age where information, if in the wrong hands, can be literally worldwide in a moment. I think it's critically important for the integrity of the system that where people are giving video evidence, recorded evidence, that they're reassured that it will only be used for that very specific purpose for which it's made, and that it's not at any point vulnerable to being misused or abused in any instance. So, yes, Jacinda Ardern touched on a quite significant provision in the bill also that effectively protects complainants, and most often women complainants, from having their sexual history paraded in front of a courtroom, in front of the public domain, simply because some particularly aggressive defence counsel might see a little bit of a way in there to discredit a complainant, to make it appear as though that woman, or typically a woman, actually is, has some weak moral code or some bad practice, some bad history in sexual matters. So no doubt there's the rock star or two, or the odd exhibitionist who's quite happy to have the intimate details of their sex life paraded to the world. But for the average person, particularly a complainant in a legal case, that would be most unpleasant and extremely damaging and traumatising for an individual. So I think we need to acknowledge that's a very good, it doesn't entirely stop such information or such evidence being given, but a judge in this instance would need to be very well convinced in advance that there was legitimate reason for that person's sexual history to be given as part of the evidence or part of the court case. So that's a very positive and useful provision in the bill. The bill also, and again as we've heard, it introduces a presumption that all witnesses under the age of 18 will use some so-called alternative methods of giving their evidence, and that's a very good thing. The alternative methods obviously meaning that their identity can be protected, or that they are taken out of that quite daunting and even intimidating sort of courtroom environment, that they can pre-record their evidence, or that they can sit behind screens, whatever the most appropriate mechanism might be to ensure the privacy and well-being of that person under the age of 18. And on that point, I would hope that the government, and particularly ministers and the cabinet, would give some thought to the provision we've embedded now into this Evidence Amendment Act when they're making decisions about whether or not all children up to the age of 18 should be included in the youth justice system. At the moment, we have this unfortunate situation where in most situations, 17-year-olds are treated as adults. There is no defensible reason why we should maintain that unfortunate situation. It's at odds with our international commitments to the UN Convention. You'll be aware, of course, that recently the House will be aware, members will be aware, that recently 33 organisations wrote an open letter to the Prime Minister and to the Cabinet encouraging them to include 17-year-olds, anybody under the age of 18, to be dealt with in the youth justice system, as this bill encourages us to do. So those 33 organisations who signed that open letter included UNICEF, Youth Law, Barnardo's, Pillars, the YMCA, the Prison Fellowship. These are not radical, mad-eyed organisations. These are very conservative organisations with a long history, a lot of credibility, who genuinely believe that we should not treat 17-year-olds as adults for the purposes of the justice system. And we absolutely endorse that. So having managed to smuggle that into my speech, I will quit while I'm ahead. And simply, I will reflect on the committee. I sat on the committee for most of this bill. It was a good process. It was very positive. Points were debated, discussed, argued on occasion. We got good outcomes, and I think we can stand proudly by what I think is a very good piece of legislation. Thank you.